This Council now becomes Committee of the whole Council to consider the Construction Industry Security of Payment Bill. Members may refer to the appendix to the script for the debate and the voting arrangements for the bill. Members have been informed that the committee will conduct a joint debate on the clauses, schedule, and amendments, including the new clause. I now propose the question to you that the following clauses and schedules stand part of the bill. Clauses 1 to 71 and schedules 1 to 4. Secretary for Development will move amendments which seek to amend various clauses and Schedule 3 and add new Clause 49A. Members may refer to the appendix to the script for details of the amendments. Members may now proceed to a joint debate on the clauses, schedule, and amendments. I will first call upon the Secretary for Development to speak, but she is not required to move the amendments at this stage. Then I will call upon members to speak. Upon the conclusion of the joint debate, the committee will first vote on the clauses and schedules with no amendments standing part of the bill, and then deal with the amendments according to the arrangement in the appendix to the script. Secretary for Development. Chairman, I now move the government's amendments to clauses 2, 6, 9, 22, 25, 38, 39, 44, 46, 48, 49, 51, 55, 56, 58, 59, 61, and Schedule 3 of the, and also the new Clause 49A of the Construction Industry Security of Payment Bill. The contents of the amendments have been set out in papers previously issued to members by the Legislative Secretariat. The amendments have been prepared with reference to the suggestions of the Bills Committee after careful consideration. They mainly seek to enable the provision of the bill to better reflect the legislative intent and to better tie in with the operation of the future adjudication and court proceedings. I will now outline the main amendments, which fall into 4 areas. 1. Set aside and enforcement applications. Clauses 48 and 49 of the bill provide that a party to an adjudication may apply to the court of first instance for the setting aside or enforcement of a determination. We have considered the views of the Hong Kong Bar Association in its letter to the BC dated the 21st of October. We have also discussed the point with the judiciary. In order to enable the court to use its resources more effectively and to cope with its operation, we propose to 1. Empower the court of first instance and also the district court to deal with applications for setting aside or enforcing determinations within their respective jurisdictions. 2. Amend Clause 48(1) such that the court may, on application, set aside the determination in whole or in part. 3. Clarify when the court does not grant an enforcement application. 4. To provide suitable flexibility in the time limit within which the court is required to grant leave for enforcement applications. And 5. To empower the Chief Judge of the High Court to make rules as required on set-aside and enforcement applications so that the court can handle these applications with greater ease. These 5 amendments mentioned relate to clauses 22, 44, 48, 49, 55, and the new clause 49A. The second area is the resignation of adjudicators and potential conflict of interest concerning an adjudicator. Clause 38 of the bill provides that the parties to an adjudication may be represented by other persons. In light of the latest development of the arbitration rules, the administration, or rather the government, proposes to amend Clause 38 such that where the parties to an adjudication intend to change their representatives, including adding a new representative or replacing an existing one during the proceedings, the adjudicator has the power to bar the new representative from joining the proceedings if the adjudicator believes that appointing such a new representative will give rise to a conflict of interest or justifiable doubts as to the adjudicator's independence or impartiality. Separately, on Clause 39, Notice of Resignation of Adjudicator, in response to the BC's suggestion, the clause will be amended to state that an adjudicator resigning under Clause 39.1 and 39.3 should serve a written notice of resignation on the same day on each of the parties and on the adjudicator nominating body. The resignation will take effect on the day the written notice is served. Area 3, that's about Schedule 3, specified bodies. Telecoms companies will carry out construction works involving specified structures. So, in response to the BC's suggestion, we add the major telecom service providers as specified bodies to Schedule 3. The fourth category has to do with drafting amendments to certain provisions to make sure that the provisions better convey the intent of our substance in simpler terms. So these changes include 1. Adding Clause 48.1aa to provide more clearly that a party to an adjudication may apply to the court, and that includes the court of first instance and the district court, for setting aside the determination. 2. Amending Clause 48.4 to state the amount of security to be paid by an applicant for setting aside a determination. The procedures will be set out in rules to be made by the Chief Judge of the High Court under new Clause 49a. 3. Amending Clause 51.2e to state that if the payment dispute of the adjudication arises from a construction contract between the claiming party and the paying party, information on the adjudication proceedings or determination may only be disclosed in other adjudication proceedings, court proceedings, or other dispute resolution proceedings under the same contract between these parties. We also propose amending Clause 56.1. Here, in the first phase of the ordinance's operation, when an extension of time is involved in a private contract, but if the payment dispute only turns partly on the EOT, then the adjudicator may still deal with the part that does not involve the EOT. Moreover, in response to the BC suggestions, we also move an amendment to spell out the functions of the Secretary, and that includes giving appropriate directions to A and Bs under Clause 61.2d, such as directions about the content of the adjudication rules, practice notes, and codes of conduct for adjudicators under Clause 63. This is where the Secretary can give directions. Apart from these amendments, we also have other drafting and technical amendments, but they leave the substance of the provisions unchanged. The Bills Committee had no objection to these changes. I urge members to support and pass my amendments. Thank you, Chairman. Mr. Tony Tse. Thank you. The Bills Committee on this bill held 11 meetings. The Secretary for Development moved 39 amendments. That's quite a lot. We had many rounds of industry consultations over the years. So this has been a major undertaking. This shows the government consulted extensively and the government has been responsive to comments. Continuous improvements have been made to meet the needs of the local construction scene. Some people have other views, but we cannot afford further indecision and inaction. Many amendments have to do with how adjudications will work, as well as the appointment of adjudicators and guarding against conflict of interest. During the BC's deliberations, many members wondered if Hong Kong had enough professional adjudicators with experience in works and procuring. I'm from the landscaping and architecture sector. I know people who manage works projects. They convey similar concerns. They manage projects ranging from 2 or 3 years for straightforward projects to 8 or 10 years for more complex projects. You go through planning, design, tendering, construction, testing. These people know the contract best. They know best, and they are in the best position to give advice, independent professional advice on costs and quality. The bill says within 55 working days, an adjudicator is expected to make the determination. The industry wondered why a third party new to the matter can go through all the materials within 55 working days and then make a fair and impartial and binding ruling on complex matters. Of course, not all disputes are complex. Whether the workers did the work, whether certain steps were taken, those are straightforward. But disputes can also arise over ambiguous matters. Say, in the acceptance stage, questions arise over workmanship, choice of materials, detailed design. Someone says the work is not up to standard. Some people ask for changes to the design. Is that extra work? Should extra fees arise? Or should that be down to the contractor and subcontractors? Given these industry concerns, the government promised that these more complex matters should be dealt with by more experienced adjudicators, and in some cases, the time frame for adjudications can be extended. I very much support the remarks from the Secretary. That is, the government will remain in touch with the industry, and then based on the circumstances and the experience, there will be continuous improvements to the rules and guidelines. As I said at the second reading debate, legislation is not the only and not necessarily the most effective way forward. It's about self-discipline on the part of the industry. Consultation, understanding, they are the way to go. The economy is struggling. We should all work together. There should be solidarity instead of resorting to the law all the time, asking for an adjudication and slowing down or suspending work. Suspension of works means workers don't get paid because they don't do the work, and that will mean project delays. That's the last thing we all want to see. I so submit. I support the Secretary's amendment. Does any other member wish to speak? Secretary, do you have anything further to say? Secretary. Chairman, I thank Mr. Tony Tse for speaking just then. I thank him for his support. Indeed, we put in years of work. There were extensive, in-depth consultations. Indeed, on many details, we have to adjust them in light of experience. That's why, for certain operational details, we will put them in the guidelines and code of conduct. Mr. Tse mentioned we need to ensure we have enough adjudicators to deal with cases. We will bear that in mind. I also thank members for their support for the amendments. So again, I urge members to support all my amendments. Thank you, Chairman. So we will first vote on the parts without amendments. I put the question to you that the clauses and schedule with no amendment as set out in the appendix to the script stand part of the bill. Would those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. We now come to the provisions with amendments. Secretary for Development, please move your amendments. Chairman, I move the amendment set out in the appendix to the script. I propose the question to you that the Secretary's amendments be passed. Those in favor, please raise their hands. Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the amendments passed. Clauses 2, 6, 9, 22, 25, 38, 39, 44, 46, 48, 49, 51, 55, 56, 58, 59, and 61 as amended, and Schedule 3. I now put the question to you that the clauses as amended and the schedule just read out by the clerk stand part of the bill. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. This committee now deals with a new clause 49A rules. Secretary for Development, you may move the second reading of the new clause. Chairman, I move the second reading of the new clause just read out by the clerk. I propose the question to you that the new clause read out by the clerk be read the second time. Would those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. New clause 49A. Secretary for Development. Chairman, I move that the new clause just read out by the clerk be added to the bill. I propose the question to you that the new clause read out by the clerk be added to the bill. Would those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. All the proceedings on the Construction Industry Security of Payment Bill have been concluded in Committee of the Whole Council. Council now resumes. Secretary for Development. President, I now report to the Council that the Construction Industry Security of Payment Bill, as amended, has been passed by Committee of the Whole Council. I move the motion that this Council adopt the report. I now propose the question to you that the Secretary's motion be passed. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Third reading.